Alright, privacy. Privacy Interpretation Library Bill of Rights. Everyone has the right to private, confidential of the library use no matter of the origin, age, background, views recognized by the fear of the privacy of the risk, lose of the freedom to explore idea of privacy essential for the free speech, free thought, free association. Courts recognize First Amendment rights to access information publicly funded libraries. Courts of the uphill for the privacy under the U.S. Constitution. Many statutes guarantee privacy with the constitutional laws. Many court decisions have defined the extent of the rights of the law. Right of privacy means being able to seek information in person online without fear of the judgment. Confidential within the libraries use the potential of identifiable information keeps it private. Article 3 of the American Library Association Code of Ethics states that confidential covers the information sought or received and resources consulted, borrowed, acquired, or transmitted. This includes but not limited to reference questions, interviews, circulation records, digital interaction records about using library resources, services, programs, and facilities. Protection of the privacy content as long with the Central Libraries, AIL, the American Library Association recognized the right to privacy since 1939, and the current American Library Association policies affirm the confidentiality of the free inquiry. Article 7 of the Library Bill of Rights clearly states users have the right to privacy and confidentiality. Rights of the library users lack of private confidential chilling effect with the use of the selecting, accessing, the using the library resources. Everyone have the right to the library without unjust surveillance and intrusion, and the minors have the same right to the advocacy with adults. Privacy as adults. Libraries even accept the data to be protected with the kept private, and many states have the legal rights to the protection unless required by law. Of the Family Education Rights and Privacy Act of the library should never have the policy with the practice limited rights. Limited users' rights based on age, disability, housing status, immigration status, involvement, criminal justice system, religion, ethnicity, sexual orientation, general identity, other forms of identity status. If required by the library, should consult with the legal counsel before limiting privacy rights. Libraries should have the duty to inform users about the personal identifiable information. The library should have the data collected securely to retain. Users should always have the choice to opt any of the non-essential data collection. They should be able to opt out again with any time that all non-essential data collection should be turned off by default. Libraries should give you the control over the many of the privacy choices as possible. Privacy options should be clearly displayed but easy to find and understandable for all. Library responsibility. The library has the ethical commitment to provide access to the information with the monitoring used to with the filing privacy law to maintain clearly updated publicly available privacy policies. Policies should state what data is being collected, who shared with it, how long it is kept. That everyone in the library, including with the volunteer, with the duty with respect, protect with the privacy with the library should provide ongoing privacy with the training library workers, governing body with the user of the National Information Standard Organization, consensus principles, use of the digital privacy of the library, publisher of the software provider systems recognize that effective management and delivery of the library for the main require of the library even to opt out of the provision of the personal data in order to access library resources, receive library service, user personal data that should be only used for the purpose disclosed to them and to what the content. Data protection libraries should clearly define that any of the collection personal library use of the data is transparently disclosed, use of the retained minimum amount of the time necessary and minimized when possible. Any data collection analysis should be anonymous, aggregated, it should never be linked to the personal information. Biometric technology like facial recognition do not align with the library mission facility accessing without just surveillance. No matter what technologies, anyone who collects either the personal identifiable information, any of the format has the legal or the ethical duty to keep confidential library security practice to safeguard personal information. Should be current and comply with state, local, and national standard with the NISO consensus principles. With the digital privacy of the library publisher of the software provider systems require the practice to encrypt personal data both at rest and in transit, promptly update system software to fix vulnerabilities, establish system procedure with the policy with the controlling access sensitive data, provide secure training for those with the data access, maintain the procedure with the bench for reporting, incident response, setting clear policy system software network security configuration and auditing. Libraries should follow the principal purpose limitation, storage limitation of data minimization when collecting and retaining library use data. They should only collect the store with the personal identifiable information required for the specific clearly disclosed purpose. Libraries should have the regular review of the data collection retention policy to identify the collector or user data that no longer necessary with the developing data management policy. The library must follow state institutional or the government retention requirement of the industrial privacy security standards. Libraries should routinely update with the procedure of the collecting and maintaining user data. Library vendors should never share with the personal identifiable information third parties or with the vendor unless they have explicitly given the permission when they are required to law with existing contract. Libraries governing institutions share with the vendor agreement to retain library ownership of the use of the data. But these agreements show with the audits, however, the vendor can collect and retain access of the data. They should also state with the use of the data. Confidential cannot be used or shared with the library permission. Vendors for handling user data should have the publicly available privacy policy with the files of the ISO consensus principle as contract near expiration. Libraries should negotiate future contracts include with the privacy safeguard. Law enforcement records should only be shared with the respondent of the promptly executed court-ordered legal process. Law enforcement may request library records to have that believe that are relevant to an investigation. Libraries should have the clear procedure for handling these requests. Staff should be regularly trained on the following procedures. In conclusion, the American Library Association affirms the privacy rights for the essential for the intellectual freedom and the core value of librarianship, the rapid advance for the technology, and for the risk of the exposing use of the personal identifiable information library use data. Use of the new technology, the libraries may conflict with the Library Bill of Rights. Library workers may rely on collecting, using, sharing, monitoring, and tracking user data. Libraries should prioritize privacy with design, delivering program services, but they should carefully review their own policy procedures and those of their vendors. Privacy is the foundation of the library with the reason of the remain trusted parts of every community. Alright, and that was Privacy Interpretation of the Library Bill of Rights.